Another great interview for you guys, of course, on TYT Interviews. It's going to be great. Lisa Bloom, who used to join us all the time back in the Current days when we had the Young Turks on Current. Lisa was the host of her own show on TruTV from 2001 to 2009. It's called Lisa Bloom Open Court. She's with Avo.com. But most importantly for today, she's written a new book about the George Zimmerman trial, which we covered a lot on Current and obviously here on the Young Turks online as well. The book's called Suspicion Nation, the inside story of the Trayvon Martin injustice and why we continue to repeat it. Now, I could list you all the TV stations Lisa's been on, but it'll take half an hour. Okay, so now, when we first started reporting on this Zimmerman situation with Trayvon Martin, Lisa, we were actually one of the first national shows to do it. But what we focused on was the injustice that Zimmerman had not been arrested and that he was not going to go to trial in the beginning. And then because of a lot of the publicity and the spotlight that was put on it, he wound up getting arrested and tried. And then we thought, well, look, it'll go to a jury of his peers, so we've kind of done our job, and then whatever the jury decides, the jury decides. But it turns out that it wasn't that simple, right? And in your book, you talk about how the case could have gone a totally different way and that there was an injustice within the trial.
Right. What I say is this was a very winnable case that was lost. So I covered this trial gavel to gavel for MSNBC and for NBC with an open mind, because this is a criminal trial and our system has many flaws, but requiring proof beyond a reasonable doubt is not one of them. So I wanted to be sure the evidence was really there to convict him. And initially, I'd say the first week, I thought, wow, this really looks like a self-defense case. And I think people are going to be disappointed, but I'm not seeing the evidence to convict him. But something happened about halfway through the trial that really changed my view, and that is there was a very strong piece of evidence that the prosecution had, but they were not arguing. I would also add that race was being argued by the defense in a very disturbing way, that Trayvon Martin was called a match to burglars in the neighborhood. Well, the only match was skin color. And the prosecutors were not on their feet objecting to that racial characterization. So after the trial was over, well, let me just back up for a second. I knew this was going to be an acquittal, and I said so on the air before the jury came back, because both sides were clearly arguing reasonable doubt. And when that happens, a not guilty verdict is the only possible outcome. After the case was over, I thought I would just go back to my life, go back to my law firm, continue being a legal analyst on the next big case. But honestly, Cenk, I couldn't put this behind me. I felt that a terrible injustice had been done in that courtroom. And I know many people feel in their gut that something went wrong in this case, but a gut feeling isn't good enough for me. You know, I needed to look at the evidence. So I did new interviews of jurors, witnesses, and the lawyers in the case, and the result is my book. And frankly, it's even more disturbing than I thought. I mean, people are calling this appalling, outrageous, you know, every word you can think of. From the missed opportunities that the prosecution had in this case, the evidence they had, they didn't argue, the expert witnesses who wanted to testify, who were not allowed to testify, the just abysmal job they did in closing argument, it guaranteed this outcome.
So let's break it down a little bit. When you say both sides argued reasonable doubt, what do you mean by that?
Well, clearly the defense did, right? The prosecution never came forward with their own theory of the case. I mean, this is unheard of. I've covered hundreds of murder trials. I've tried many, many cases myself. You cannot win in a courtroom if you don't have your own theory of the case. The prosecution used the defense version of the case throughout. So some people who followed the trial will remember there was a mannequin, and the defense used the mannequin to reenact the fight, as they called it. I wouldn't even have conceded that it was a fight. The prosecution essentially used that same mannequin in the same position, just arguing the details around the edges. And probably most importantly, in closing arguments, the prosecution asked a series of questions to the jurors, instead of using declarative statements connecting the law to the facts as they would in any other case. You can't just ask jurors questions in closing arguments. You have to give them a roadmap to conviction, and the prosecution never did that.
So now, of course, Zimmerman said throughout, he jumped me, and I felt like I was in danger for my life, and I got the cut in the back of my head because he was pounding the cement, etc. If you were the prosecution, what would you have said was the alternative story as to what actually happened that night?
Well, the alternative was presented by Rachel Gentel. Now, I remember her. She was a 19-year-old, heavy-set young woman. She was the friend of Trayvon Martin, and I tell her story in the book for the first time. It's another appalling story about how she was completely unprepared to testify in the highest-profile case in America. The prosecution basically just put her up on the stand, left her to fend for herself. She had an underbite, which caused her to speak in a way that sounded like she was muttering. It sounded like she wasn't confident. but it was a medical condition. It had nothing to do with credibility. They should have pointed that out to the jury. At a minimum, they should have prepared her, and they didn't. Now, her story was she was on the phone with Trayvon Martin at the time that he first saw George Zimmerman and was afraid of him and ran away from him. Then he sees Zimmerman again, and she heard the first words that these two men exchanged. She was the most important witness in the trial. But the jury, we now know, and I reveal in the book, the jury now know, the jury said we just completely discounted everything Rachel Jeantel had to say, which is appalling.
Why did they do that?
Because she was a poor communicator, and because she used words that were inflammatory in the courtroom. She used the word Nigga and attributed it to Trayvon Martin. She used the word cracker. Well, you know what? This is the way teenagers talk. Some teenagers talk. And this could have been easily explained. And I have examples in the book about how this could have been explained. This was a couple of teenagers talking to each other. These weren't racial terms in reference to a white guy that Trayvon Martin saw. But the important part of her story was that she says that when the two men met, and this is at the end of the call, that Trayvon Martin said, "Why are you following me?" Which is a perfectly reasonable question. Right. George Zimmerman said, "What are you doing around here?" She then heard the sound of thumping on Trayvon Martin's chest where his phone was connected. She heard the sound of wet grass, and then she heard Trayvon Martin say, "Get off, get off." So these are defensive words, and certainly completely inconsistent with Zimmerman's story that he was waiting in the bushes. By the way, there were no bushes he could have hidden behind. Waiting in the bushes to jump out and attack George Zimmerman. I mean, these are the kinds of things the prosecution was blind to in the trial.
So, to me, one of the things that Zimmerman had said throughout that I found so incredulous, and I couldn't believe that anybody would believe it, was, well, yeah, okay, I followed him, right? And the cops told me not to follow him, but, you know, I was trying to help them, etc. But then I went right back in my car, and then as I was, you know, in the process of that, he jumped me.
Right.
Like, but that's not how normal human beings react, right? And so, did the jury believe? Did the jury believe that? And if they did, like, if you were the prosecution, how would you have broken down that argument? I keep wanting to yell at the jury, like, "Come on!"
Right.
He didn't go back to the car. He kept chasing him. It was obvious.
So in the first chapter of my book, it's inside the jury room during deliberations, and so we know now what happened. And that is that 4 out of the 6 jurors wanted to convict George Zimmerman. Even given the terrible job that the prosecution did, they felt in their hearts that he was guilty. But they didn't have the facts and the law to convict, and so they did the only thing they could do, which was acquit. Now, here's the most important piece of evidence in the case. George Zimmerman, on videotape the day after the shooting, demonstrates the gun was holstered behind him, inside his waistband and behind him. He demonstrates that 3 times on videotape. The prosecution didn't use that at trial. Well, his story was he's down on his back, Trayvon Martin is on top of him, Trayvon sees the gun, reaches for the gun, threatens to kill him, and at that point, Zimmerman had no choice, he says, but to pull the gun and shoot in self-defense. If that story is true, he does win on self-defense grounds. The problem is, unless Trayvon Martin had X-ray vision, there is no way he could see through the bulk of Zimmerman's body to a gun holstered behind him. Incredibly, the prosecution didn't argue that throughout the trial. At the very, very end, after I was talking about this a lot on TV the last week of the trial, the prosecutor mentioned it, just mentioned it in closing argument, very briefly, didn't put all the evidence together for the jury, didn't point out it was dark, it was raining, there was a grassy ground cover, none of that. Just mentioned it and moved on.
So the one question I'd always had about the evidence and the so-called fight was Zimmerman says he's on top of me, and so I had to pull the gun and shoot him. How does he not get any blood on his shirt if Trayvon's on top of him and he shoots him like this?
That's another good point.
And did that ever come up during the trial?
No, and that's another outstanding point. Look, Zimmerman says also that Trayvon was banging his head dozens of times, he says, on the concrete. And the defense brought in this big block of concrete in closing argument to say that could be a deadly weapon. Well, yeah, it could if his head was being banged on the concrete. The problem is the concrete was a substantial distance from where this altercation occurred. And we know that because Zimmerman said after he shot Trayvon Martin, he slid out from under him. He didn't move the body. So unless George Zimmerman had a head that could extend 12 feet like a Pez dispenser, there's no way his head was being banged on the concrete. In fact, his own attorney in closing argument conceded that his claim that it was dozens and dozens of time was exaggerated. Well, what's another word for exaggerated? A lie. It's a lie. I mean, again, a prosecutor who really wanted to win this case would have used that very effectively in their rebuttal closing argument and said, his attorney has now just admitted that he lied about the most important part of this case, which is the self-defense moment and the altercation.
Trayvon shot right in the torso or chest, and if he slid out from underneath him, let alone gravity, how is he not going to get any blood on his shirt? I just don't understand that and why it never came up. Okay, so the heart of the question then goes to, why did the prosecution do this? Was it negligence? Was it laziness? Or do you have a different theory?
So I call this the blow it or throw it question, right? Did they blow the case or did they intentionally throw the case? I leave it to my readers to come to their own conclusion. I personally am not a conspiracy theorist unless I have some pretty strong evidence. So I'm not going to come out and accuse these prosecutors of intentionally throwing the case. I will say that Angela Corey took to the cameras right after her team lost the case, smiled broadly and said, "The system worked." That's a very peculiar thing. And out of the 4 prosecutors, only one of them said that he was disappointed with the outcome of the case. Angela Corey said, "We've done our job. We put all of the evidence out there so that America can make up its mind." Well, that's not actually the job of a prosecutor. They're not a documentary filmmaker or a journalist to put everything out there and let people decide. They're actually supposed to make an argument for conviction. They're supposed to connect the dots, and they didn't do that. My opinion is they never believed in this case. And I have one of the expert witnesses who I quote in the book who said, you know, behind closed doors, they all said they didn't believe that Trayvon Martin was the victim. Look, it took them 45 days, as you pointed out, to make this arrest. It took a groundswell of public demonstrations, of journalists like you saying, what's going on? He shot this unarmed kid. Why isn't he arrested?
So rather than it being nefarious, they're all racist, yada, yada, more like, well, they made us do this case. We didn't want to do it in the first place. Okay, all right, well, then this is what we'll do. We'll present the evidence and you figure it out.
They did just a perfunctory job. They certainly did not behave in the courtroom like attorneys who really believed in the case. You know, I don't think they went home and reanalyzed the evidence at night in the way that I did as a journalist covering the case, and I noticed a lot of things that they weren't arguing. I'm not accusing them of racism. I think, frankly, they're a little different than the rest of us. And the second half of my book, Suspicion Nation, is about those issues, about implicit racial bias, for example, which about 80% of white Americans test for moderate or severe racial bias that we don't even know we have. We all say we're not racist, but we walk around and we make racial assumptions about people. About 50% of African Americans also test for racial bias against African Americans. So I think that accounts for, you know, the mountain of evidence that our criminal justice system is just loaded up with racial bias. It accounts for a lot of racially disparate outcomes. You know, many people in the criminal justice system making these decisions are black or brown themselves, and yet we still have these negative outcomes. How is that possible? I think it's because of implicit racial bias.
Well, that was the original problem in not arresting Zimmerman in the first place. So, and that almost cannot be argued. It's literally, in my mind, inarguable. You have a guy who's a 17-year-old black kid who's dead on the ground, and a guy who shot him, and they don't do a criminal background check on the guy who shot him. They do a criminal background check on the dead kid.
Yeah, who's unarmed.
Yeah, they don't do tests to see if the guy who shot him is intoxicated. They do the toxicology report on the dead kid. Right. Now, why would you do that? One of them is armed, the other one is unarmed, one of them is dead, the other one is perfectly alive, one of them is an adult, the other one's 17 years old. The only reason that you would do the toxicology report and the criminal background check on the dead kid is because he's black. So I'm going to assume that Zimmerman is innocent. I'm going to assume that Trayvon is guilty, even though he's the one dead on the ground.
And add to that, after the shooting, you know, Trayvon Martin didn't have any ID on him because he was just a kid going to the convenience store to buy some candy. The police didn't knock on doors in the neighborhood, in that suburban, mostly white neighborhood, to say, hey, is this somebody you know? I think they assumed he was an outsider. In fact, if they had knocked on about a dozen doors, they would have come to the home where he was staying. The parents would have been called. His dad was out for dinner with the girlfriend. He surely would have been called by the kid who was home. And they would have learned immediately that Trayvon Martin's nickname was Mouse, for example, because he was so quiet, that it was extremely unlikely that he was the aggressor. They would have gotten the consent to check his cell phone. They would have found Rachel Gentile and what she remembers of that call, that he was saying, get off, get off. But because they didn't do that, they had Zimmerman's story from the beginning, and that was a story that they chose to believe.
So let me ask you a different question. Let's assume for a second that part of Zimmerman's story is true, right? So yes, he follows Trayvon, even though the cops tell him not to on the 911 call. But then at some point, once he runs into him, there's an altercation, and Trayvon gets the upper hand. Okay, let's assume that for a second. I don't necessarily believe that at all, but let's grant him that. would he then be allowed to shoot him and claim self-defense?
Okay, this is such an important question, and the answer is no. And I put my theory in the book of what I think exactly what happened based on all of the evidence. But no, when two guys are in a fist fight in America, one of them can't just pull out a gun and shoot to kill the other one. We're not barbarians. We actually have laws. Laws that the prosecution should have argued in this case. There are three important factors that have to be met before you can shoot to kill somebody. You have to be in reasonable fear of imminent great bodily injury or death. So let's start with reasonable. George Zimmerman said he panicked. Panic is not reasonable. The prosecution should have argued that. They didn't. Imminent great bodily injury or death. Not 5 minutes ago I was scared, now I'm safe, but I'm going to shoot. Not 15 minutes from now I'm afraid, but right now you have to shoot to save your life. And great bodily injury or death. And I think that's important because I think Zimmerman didn't like being humiliated. He didn't like losing in a fist fight, and he took the gun out in anger. What I believe actually is that Zimmerman pulled out the gun very early in the altercation because remember, he was afraid of Trayvon Martin. He said to the police, I don't even want to give you my address because maybe he can hear me. You know, he was afraid. So the idea that he would approach Trayvon Martin without pulling his gun, I think is unlikely. He wanted Trayvon Martin to stay there until the police came. And by the way, he had made a half a dozen other calls to the police in the prior 6 months, which were recorded and which were in evidence about guys in the neighborhood who he thought were suspicious. 100% of those calls were about African Americans. 100%. Prosecution didn't argue that either, by the way. So, you know, we knew his mindset. He was afraid of black guys walking down the street. He wanted to hold on to them until the police came. I am very, very sure that he pulled out his gun, which he knows is illegal, to keep Trayvon Martin in line. I think Trayvon Martin got one good punch. Some people don't agree. I think he got one good punch on Zimmerman's face because Trayvon Martin was standing his ground. And then I think Zimmerman was pointing the gun at him, threatening to kill him, and that's why Trayvon Martin was screaming and screaming and screaming for help on the 911 call because he was looking at a madman with a gun pointed at him.
So I talked to one of the leaders of these ridiculous gun groups, Larry Pratt, Gun Owners of America, I think is the group he runs. And I asked him, well, didn't Trayvon Martin have a right to stand his ground?
Right.
And he said no. Since he doesn't have a gun, he must retreat. But if you have a gun, you're allowed to.
That's not true.
Yeah, that's crazy
that's
talk,
isn't it? That's not an accurate statement of the law at
Isn't
all.
that the craziest thing you ever heard?
The only thing that's accurate about that is that white shooters who shoot African Americans are 350% more likely to be acquitted. In fact, they're unlikely to even be charged. So there's a huge racial imbalance in stand your ground laws. And I talk about that in the second half of the book. The triple threat here that's responsible for the death of Trayvon Martin and Jordan Davis and Darius Simmons and Jonathan Farrell and Renisha McBride is racial profiling, our lax gun laws, and stand your ground laws. Those are the three forces that are conspiring to take the lives of too many young, unarmed African Americans.
So one more thing about stand your ground, because a lot of people think, well, stand your ground was not used by Zimmerman defense, so it wasn't involved in the trial. But that's not true, is it? They read that in the closing, the judge read it to the jury in his closing remarks, didn't he?
Yes, I actually wrote a piece about this on the Huffington Post about stand your ground, because there's a lot of confusion about this. Stand your ground gives the defendant a lot of different rights. George Zimmerman elected not to have a stand your ground hearing before trial. Nevertheless, stand your ground definitely came into trial. It was read to the jury as part of the standard jury instructions. And we know, and this is in the book, from the jurors who they were interviewed afterwards, that stand your ground was very much a part of their deliberations and a part of the basis for their decision. By the way, it's the same thing in the Jordan Davis case. He was shot by Michael Dunn in that loud music murder trial. Anybody who thinks stand your ground did not have a part of these trials, was not watching the trials, is not familiar with the jury instructions, is not familiar with what the jurors themselves say afterwards.
So what did you find out after the trial was over that caused you to be more outraged?
Well, let's talk about what was going on inside the jury room. And there were 6 women on this jury, which is a little unusual, but that's the way it came down. 5 white women, and the 6th is a woman named Maddie, who I interviewed at length, and I tell her story at the very beginning of the book. Maddie frankly tells a story of racial profiling inside the jury room, how she was mocked and demeaned by the 5 white women, that throughout the 3 weeks of sequestration, she was, made to feel different, the way she talks, they made fun of the way she talks, to the point where she was isolating herself in her room. She was the only one who had an officer stationed outside of her room, by the way.
Really?
And she had to ask herself, is it just because my room is at the end of the hall, or is it because of my brown skin? You know, in the same way that people of color in America always wonder, am I being watched because of my color, or did I do something? So she had this strange, uncomfortable feeling. And she was in tears a lot during the trial. She also wanted to leave a couple of times. I mean, at one point she said, I'm out of here. If they put me in jail, so be it. I can't take this anymore. For example, she had a 3-month-old baby. On the weekend, one of the white jurors wanted to see her dog. She missed her dog. She was given 9 hours with the dog. Maddie asked, well, can I see my baby then for 9 hours? She was told no, because children can talk. This was a 3-month-old baby. So this feeling that she was treated differently just mounted every day. And by the time deliberations came around, Maddie felt that she had no voice. She felt very isolated and alone. I would add, this is very typical when there's one person of color in kind of a token situation. It's very hard for people to stand up. And you know, a lot of people, after they've read my book, have been tough on Maddie and said, well, I would have hung the jury. I would have stood for what I believed in. You know, I hope that people can have compassion for someone like her who, you know, had no knowledge of the legal system at all. She was a nurse's aide, mother of 8. She came into it in good faith, and to this day, Maddie is she's kind of collateral damage in this case. She says, I feel as though I carry the weight of Trayvon Martin's death on my shoulders every day. I mean, she's devastated. There are a lot of people who feel that way. A lot of people really hurt by this case. And that's also one of the reasons why I wanted to write this book, is for all of the people who just feel the pain from this case. I wanted to, at minimum, I thought, what can I do? Well, as a lawyer for many years, as a legal analyst, I can expose this injustice.
So, final couple of thoughts here. One is, if it happened in a different state, not the insane state of Florida, let's say California, right? Do you think the result would have been different?
So I got news for you. We have stand your ground here in California. It's in the standard jury instruction for self-defense. New York City has probably the worst racial profiling by police of any city in America. At least it's the best documented. There's just mountains of data that were involved in this stop and frisk case in New York, and I talk about that. So it's not just Florida. I don't want people to think it's just this case or it's just Florida. Clearly, guns are a nationwide problem in all 50 states. I think racial profiling is a problem in all 50 states. And stand your ground is in about 27 states. So I don't want to minimize this and say it's just Florida. It's not.
Okay. And then finally, if you were on that jury and you had access to all the evidence, do you think you would have convicted on manslaughter? It seems obviously based on what you're saying that you think there should have been a conviction. On manslaughter or murder?
Well, I'll put it a different way. I think the prosecutors could have very easily made the case for murder. And that's the case I make in the book. Because manslaughter is an intentional taking of a human life. Zimmerman acknowledges he intentionally shot him. It wasn't an accident. The only question is, was it self-defense? Well, for murder, all you need is the additional element of ill will, hatred, or malice. So let's take ill will. He looks out the window of his car. He sees Trayvon Martin, a stranger to him. He instantly calls the police and says, he's a real suspicious guy. He's, I don't know if I can use profanity on your show.
Sure.
Okay, he's a fucking punk. He's an asshole. These assholes, they always get away. This is the instant conclusion he comes to. If that's not ill will, I don't know what is. You mean to tell me in the altercation he got warmer and fuzzier towards Trayvon Martin? Of course not. After he got punched in the face, I'm sure he still harbored that ill will. And if there's any doubt, 5 months later, when Zimmerman lawyers up and he sits down for an interview with a friendly interviewer, Sean Hannity, he calls the killing God's plan. That is ill will. All you do, you have a clear through line, which of course the prosecution didn't argue, for ill will or hatred. I mean, that's why I say I think this was a very winnable case that this prosecution team lost.
I wonder if the prosecution didn't mention and focus on the racial bias because they were worried that the jury might also have that same racial bias and that they would be kind of perhaps in a roundabout way insulting the jury by implicating, you know, or implying racial bias in the case. So
I looked at that question very carefully, and my conclusion is that, guess what? People can handle talking about race. I've personally been a civil rights lawyer since 1986. I talk about race in courtrooms. I talk about gender. People can handle it. It's not this scary third rail. I mean, let's keep in mind, this is a murder trial. They're talking about blood and gore and guts and shooting. They think the mention of the R word, race, is going to blow the roof right off the courthouse. That's ridiculous. I think most Americans like to think that they're not racist, that they're good-hearted, egalitarian people. And if this prosecution team, look, they couldn't have done any worse. They lost the case, right? Mm-hmm. If they had argued that George Zimmerman, every time he called the police, it was about a black guy. If they had objected to the defense putting a witness on who talked about being robbed by two unrelated burglars, I mean, I would have been on my feet. What does this have to do with Trayvon Martin? It has nothing to do with Trayvon Martin. To ascribe, the wrongdoings of two African Americans to all African Americans is the very definition of racism. I think they would have gotten the jury on their side. They sure would have gotten Maddie, the one that I talk about at the first chapter of the book. Mm-hmm. I think they would have gotten more. I think that was important. And by the way, in the Jordan Davis case, same two prosecutors, same mistake failing to argue race. In that case, they had even better evidence. They had racist letters from prison that Michael Dunn wrote behind bars. He said, the more I get to know those people, referring to African Americans, the more prejudiced I am. You don't get evidence that good very often. If you've got it, argue it.
Did they not
submit
that?
They didn't argue it. And they had two African American women on the jury. They did not use that evidence in the case.
It's hard not to come away from your book thinking there's something wrong with the prosecution. And that is really unsettling, because we thought the main injustice was that he wasn't arrested in the first place.
Right.
But if they threw the case after he was arrested, well, then that injustice was not solved at all.
Well, and it was magnified because then our system really let this family down. It's bad enough that they lost their son, their brother, but then the system wasn't there for them. There was no accountability. It's really a double tragedy.
Yeah, and unfortunately, since the Trayvon case, as we saw with the William Dunn case and Renisha McBride, and over again, assumptions about race leading to an unarmed African American, usually youngster, getting killed, and oftentimes people getting away with it. And
well, that's why I call the book Suspicion Nation. I think we have to get past these suspicions. I think we have to recognize that we have them. And frankly, many good-hearted people have them. Many progressives have these assumptions and fears. It's the African American as criminal stereotype. It's a very deep, pernicious stereotype in American culture. And we need to get past it. As I point out in the book, when George Zimmerman got out of his car that night, he was more likely to be hit by lightning than attacked by Trayvon Martin. This fear we have of young black guys walking down the street is completely misplaced. I, as a white woman, for example, am 6 times more likely to be victimized by a white guy than a black guy. Most crime is intra-racial, white on white, black on black. So we really have to get past these suspicions and fears of our neighbors.
Yeah, finally, it's those stereotypes that drive me the craziest. They say the stereotype is Mexicans are lazy. Have you ever met a Mexican? I mean, to say that, for example, people in Los Angeles, to say that Mexicans are lazy, it's the craziest thing you've ever heard.
People in Los Angeles.
Yeah, at least in Los Angeles, right? In our experience. And then African Americans, after you violently enslaved them for centuries, you say, oh, they're violent. Well, there's pretty good evidence that it's actually the reverse. And then to put the stereotype on them, and then that leads to the shootings, that leads to the acquittals, that leads to all these different things. It's a double injustice. Yeah. And the more I talk to you about it, the more frustrated I get.
Well, you should get angry. We should all be angry about this.
Right. All right. Well, it's a fascinating book, Suspicion Nation. If you cared about the Trayvon Martin case, as a lot of us did, certainly worth checking out. Lisa, thank you so much for coming in.
Thank you, Cenk. I appreciate it.